3, 2. Flag salute. Lord, please bless this meeting and all of participants. See that we all arrive home safely, and help us as commissioners to make wise decisions for the city of Canby and everybody that participates in this process. In your name, amen? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. So thank you all for coming today and participating. I see we have citizen input on non-agenda items. Mr. Peter Hostetler, is that correct?
Correct.
If you will sit there and give us your name and address and tell us what you're all about.
Name Peter Hostetler, address 10060 South New Arrow Road, Canby, Oregon. I wanted to bring to the attention of the Planning Commission an issue that came up in one of my latest planning applications, and it's in regards to the roads that exist in the city of Canby that are owned by Clackamas County and are subject to their ordinances. And in my particular application, it was handled really well by staff, but the issue started with the pre-app meeting, and it was relayed to me that the county wasn't notified of the pre-app meeting, and they should have been notified because the property that I was looking to partition or subdivide was adjacent to a county-owned road, or was right on a county-owned road. And so they didn't show up at the pre-app meeting, and you know, months after that pre-app meeting, we get information from the county saying this can't happen like this because this is a county-owned road and these are our ordinances. And it would have been helpful to have known that at the time that it was a county-owned road and that they would have shown up at the pre-app meeting. But I don't think that, and it's not to throw the city staff under the bus, they've done a great job, but it's like they didn't notify the county because it's odd that, oh yeah, we got to notify the county as well because this is a county-owned road inside the city limits. So South Redwood Street is what I'm talking about, but I know there's other roads. South Redwood Street is wholly contained inside the city limits, but the county owns it. And it was told to me that the county offered the city money to take ownership of that road, but it was the city decided not to take ownership of that road because it didn't meet city spec. Well, South Redwood Street is a lot better than some of the city-owned roads in town, I'll just say that. So it just sounded like a cop-out and just a shirking of a responsibility by the city administration of not taking ownership of that road. What that leaves us as property owners and citizens of Canby is that the fact that now we're not just subject to your ordinances or the city ordinances, we're subject to the county ordinances too on a street that's wholly contained in the city limits. So the things we were wanting to do would have been fine if it was just a city city ordinance, but because the county's involved, because we've been annexing land into the city, and the growth boundary is here. You know, now we have roads owned by another jurisdiction that we're subject to as citizens of Canby, which doesn't make any sense, and it's not being handled always perfectly at the city level with the city staff and getting things notified in time. This cost me extra time and extra money on this application, which was pretty straightforward, but was kind of complicated with the fact that we have a county-owned road inside the city limits that's wholly contained inside the city limits. So that's just my 2 cents on the matter. I thought bringing it to the attention of the Planning Commission, because you guys are the ones that, you know, look at these things. It might be well worth your time to research county-owned roads within the city limits that, you know, the city should really take ownership of, because they're serving the citizens of Canby and they're not necessarily being maintained by the county because the county doesn't care about them anymore, and they would really rather the city take over them, and they're willing to pay you money to do so. So that's my 2 cents on the issue.
Any questions for Peter? Thank you. Thank you, Peter. We will at this time approve the minutes from the August 28th meeting and September 11th Planning Commission minutes.
Mr. Chair, I move we approve the meeting minutes from the August 28th and September 11th Planning Commission meetings.
Second.
All in favor, say aye.
Aye.
Opposed? Okay. Brian, any new business? None. Okay. Okay, so we are now going to consider a request for a minor land partition to create 2 parcels in the Sequoia Grove Industrial Park, 279 South Sequoia Parkway, MLP 17-05, Craig Galvin and Jeff Gordon. The matter presently before the hearing body requires a public hearing. All interested persons in attendance shall be heard on the matter. If you wish to testify on this matter, please be prepared to step forward to the microphone at the appropriate time. State your name, mailing address, and interest in the matter. For those people other than the applicant that are interested in testifying as either proponents or opponents, please sign in on the sheet or speak up when we call for testimony. For longer presentations, proponents and opponents may buy time from one another. In so doing, those either in favor or opposed may allocate their time to a spokesperson who will represent the entire group. You may be limited by time for your presentation. Generally, the applicant will have a total of 15 minutes to speak. The proponents will be given 5 minutes each. The opponents will be given 5 minutes each. And those thought to be neutral on the matter will be given 5 minutes each. The applicant will then have 10 minutes for rebuttal. All questions must be directed through the chair. Any evidence to be considered must be submitted to the hearing body for public access and to become a part of the record. All written testimony received both for and against prior to the hearing shall be summarized by staff and presented briefly to the hearing body during the staff report. Testimony and evidence must be directed toward the applicable review criteria contained as indicated in the staff report, the comprehensive plan, or the applicable land use regulations which the person believes to apply to the decision. Failure to raise an issue accompanied by statements or evidence sufficient to afford the decision maker and the parties an opportunity to respond to the issue may preclude appeal to the Land Use Board of Appeals based on that issue. Failure of the applicant to raise constitutional or other issues relating to proposed conditions of approval with sufficient specificity to allow the local government to respond to the issue may preclude any action for damages in circuit court. Everyone present is encouraged to testify, even if it is only to concur with previous testimony. At this time, I would ask that any member of the hearing body who has a conflict of interest to please indicate the nature and extent of the conflict and whether you intend to participate in or abstain from the hearing from hearing the present matter. Okay. Also, if any member of the hearing body has had any ex parte contact with anyone prior to this hearing, including a visit to the site, please declare the nature and extent of such contact at this time. Okay. Does any member of the audience have any questions for any commissioner regarding conflict of interest or ex parte contact? Okay. The public hearing will be conducted as follows. First, we'll have the staff report, then questions, if any, by the commissioners. Then we will open the hearing for public testimony. The applicant will have not more than 15 minutes. Proponents will have not more than 5 minutes each. Opponents not more than 5 minutes each. Neutral not more than 5 minutes each. And rebuttal by the applicant not more than 10 minutes. That time will close the public testimony. Then more questions by the commissioners. Then we will discuss and deliberate, and there will be no additional testimony unless specifically allowed by the chair. A decision shall be made by the hearing body at the close of the hearing, or the matter will be continued to a date certain in the future. This will be the only notice of that date you will receive. Does anyone have any questions? Okay. Brian.
Thanks a lot, Chair Savory, and good evening, commissioners. This on your screen shows you the it's parcel 2 of the Sequoia Grove Industrial Park. The parcel 1 of the original partition is the Sequoia Grove apartment complex that's directly to the north-ish, I guess. And so they're taking this entire tract with frontage along the curve in Sequoia Parkway, and the proposal is to partition that into 2 parcels. And looking at the next slide here of the proposal, you can see the proposed lot lines going in this position here. So now we'll have a parcel 1 here that is currently vacant, and the rear portion is now developed with the student services bus barn for the school district. They have a building in this corner, and the rest of it is bus parking. And my understanding is this was kind of a modification to the original site and design review that the Planning Commission approved for this entire property. And so if you remember back that far, there was a large building A shown to be up in this parcel. So that's still planned and has been approved. And so at any time they want to move forward and build that building, they'll be able to do that. I mentioned in this staff report, and we made it a condition of approval, that before development on parcel 1, there is a need, however, for them to do a update to the traffic study that was done when the whole development was approved, because it didn't account for the bus barn use. It came in as a moderate amendment to the previous site and design, and it took up part of the traffic that would have been generated by the vacant parcel here. And so the overall site's going to generate more traffic than we anticipated in the study that was done. So they'll have to update that before they can move forward with development of that site. So what you'll see from this, though, is parcel 2 doesn't actually have lot frontage up on the public street, and so there are access easements where the existing road is currently constructed, and utilities are coming through that same area down to serve parcel 2. And so that all is going to be handled through that common access and maintenance agreement and utility easement that serves that parcel that doesn't have the frontage. I think I mentioned a couple of these already. We have a street tree demonstration project. If you've driven South Sequoia Parkway, you'll notice that years ago, the Parks Department and our city arborist that we had at that time, when we say a demonstration, they planted every kind of street tree that was on our approved street tree list for planting in residential neighborhoods and such, and they labeled them so you can check to see what a mature, as it's growing, a mature tree of all of those different types would be. Some of those trees we believe are still located along the frontage of this parcel that's being partitioned, but we didn't double check because they've moved some of them as they constructed one of the driveways, and they moved the trees over where the Sequoia apartment grove was happening. So we just made a condition here that they will make the street trees part of their landscape plan when they develop that parcel, if they're needed, because we're not positive if every one of them is in place right now or not. The second condition is kind of an iffy one too. At the current point in time, we don't believe any utility easements are necessary, but we put this in here just in case one of the utility providers, whether it be the natural gas company or any of the others, at the last minute decide they need a parallel easement fronting Sequoia Parkway. We always grant them what they need in order to properly serve each of the properties. And so this just provides that assurance that we'll be able to get that easement if for some reason at the last minute someone needs one. We made a point of reiterating it was a huge deal when this original parcel was created that there not be any additional driveways out onto Sequoia Parkway. It was part of the rezoning that was approved that created the zoning for this property when it and the adjacent property put a restriction on the uses that could occur on this property when it was rezoned. Actually, this property itself wasn't rezoned. The apartment complex was rezoned. But as a result of that, they put a restriction that this parcel, even though it's heavy industrial, would only have light industrial uses. So I was just kind of reminding you of that condition. Can get lost in the bowels of our filing drawer without that. And then I already mentioned the traffic study prior to developing parcel 2. So are there any questions about this application?
Okay, do we have a proponent for this? You'll just state your name and address.
My name is Craig Galvin. My address is 38831 Barlow Parkway, Sandy, Oregon. I'm the applicant and the licensed surveyor preparing the application and hopefully the partition plat for this development. I think Brian covered it pretty well. The lot that's being partitioned was just created about a year ago by a partition that was recorded in 2016. Unfortunately, at that time, this lot was not proposed to be part of that development. Otherwise, that would have been divided as well. But so we tried to kind of retrofit the utilities to work with this land development, and that's what precipitated the easements and so on that you see on the proposed plat. But all of the existing utilities to serve parcel 2 are already in place. The existing driveway is already in place. And as Brian mentioned, when parcel 1 is developed, the frontage improvements and street trees and so on will be put in place at that time. So unless you have any questions, I respectfully request you approve the partition.
Any questions for Craig?
No.
Okay. Thank you very much. Excuse me. Do we have any opponents of this proposal? There's anybody that is neutral on this matter that would like to speak? Obviously, then, no rebuttal. So I will close the public hearing. Any further questions on this? Then I will entertain a motion to approve the request for a minor land partition to create 2 parcels in the Sequoia Grove Industrial Park, 279 South Sequoia Parkway, MLP 17-05, Craig Galvin and Jeff Gordon.
Mr. Chair, I move that we would approve the request for minor land partition to create 2 parcels in the Sequoia Grove Industrial Park, 279 South Sequoia Parkway, MLP 17-05, Craig Galvin and Jeff Gordon.
Have a second.
Second.
All in favor say aye.
Aye.
Opposed? Okay, thank you very much. Now we will consider a request for a minor land partition of 861 South Redwood Street into 3 parcels and lot line adjustment for the existing lot line between 861 and 853 South Redwood Street, MLP 17-06 / LLA 17-02 Hostetler. The matter presently before the hearing body requires a public hearing. All interested persons in attendance shall be heard on the matter. If you wish to testify on this matter, please be prepared to step forward to the microphone at the appropriate time. State your name, mailing address, and interest in the matter. For those people other than the applicant that are interested in testifying as either proponents or opponents, please sign in on the sheet or speak up when we call for testimony. For longer presentations, proponents and opponents may buy time from one another. In so doing, those either in favor or opposed may allocate their time to a spokesperson who will represent the entire group. You may be limited in time for your presentation. Generally, the applicant will have a total of 15 minutes to speak. The proponents will be given 5 minutes each. The opponents will be given 5 minutes each, and those thought to be neutral on the matter will be given 5 minutes each. The applicant will then have 10 minutes for a rebuttal. All questions must be directed through the chair. Any evidence to be considered must be submitted to the hearing body for public access and to become a part of the record. All written testimony received both for and against prior to the hearing shall be summarized by staff and presented briefly to the hearing body during the staff report. Testimony and evidence must be directed toward the applicable review criteria contained as indicated in the staff report, the comprehensive plan, or the applicable land use regulations which the person believes to apply to the decision. Failure to raise an issue accompanied by statements or evidence sufficient to afford the decision maker and the parties an opportunity to respond to the issue may preclude appeal to the Land Use Board of Appeals based on that issue. Failure of the applicant to raise constitutional or other issues relating to proposed conditions of approval with sufficient specificity to allow the local government to respond to the issue may preclude an action for damages in circuit court. Everyone present is encouraged to testify, even if it is only to concur with previous testimony. At this time, I would ask that any member of the hearing body who has a conflict of interest to please indicate the nature and extent of the conflict and whether you intend to participate in or abstain from hearing the present matter.
Mr. Chair, as mentioned last time, the Hosteller family and I go to church together, but it doesn't have any bearing over any decisions that I would make tonight. So do you plan to participate?
Okay. Also, if any member of the hearing body has had any ex parte contact with anyone prior to this hearing, including a visit to the site, please declare the nature and extent of such contact at this time. We already know about you.
I drive by it several times a day.
Okay. Does any, excuse me, does any member of the audience have any questions for any commissioner regarding conflict of interest or ex parte contact? Okay. The public hearing will be conducted as follows. First, we'll have the staff report, then questions, if anybody, by the commissioners. Then the applicant will have no more than 15 minutes to speak. Proponents, other proponents, not more than 5 minutes each. Opponents, not more than 5 minutes each. Neutral, people that are neutral on the matter, not more than 5 minutes each. And rebuttal by the applicant, if necessary, not more than 10 minutes each. That time we will close the public testimony. Questions, if any, by the commission. Then we will have discussions and deliberation by this hearing body, and no additional testimony will be allowed unless specifically allowed by the chair. A decision shall be made by the hearing body at the close of the hearing, or the matter will be continued to a date certain in the future. This will be the only notice of that date you will receive. Does anyone have any questions about the procedure outlined in this hearing? Okay. Brian.
Okay, just real briefly then, a reminder that you're actually reviewing in both a minor land partition and probably, if you think of it in a sequence, a lot line adjustment first between the two tax lots that are existing in place today. So this is a drawing that shows you pretty much that there's development on two existing tax lots, and the intent of the lot line adjustment is this dividing east-west property boundary is being adjusted to basically go around this existing home on the south side so that it has the proper setbacks when the new lot line is adjusted through the lot line adjustment, which by definition doesn't create any additional lots, just makes one lot bigger and one lot smaller. And then you have development on the upper lot existing too. The minor partition is as proposed here, which is just dividing the southern tax lot with that existing home, and now you can see the larger setback here and the uneven east-west line that's being proposed. And that is also in effort to think about the possibility in the future of possibly partitioning this northern lot down the road at some time. So they're anticipating that with the lot line adjustment as well. The applicant has outlined, well, I don't know if it's really clear on this drawing, but there are some existing utility easements, some of them along this eastern edge of the property here that he's gone through a process of soliciting approval from all of the utility companies that have a right to be in a portion of some of these utility easements that are on the site, and he's proposing to vacate a portion of those and has gotten approval from all entities that have a right to be in them to do that. So when he makes his partition plat of this, he won't be showing that portion of the utilities that he's gotten approval to vacate, basically. And that will help make at least Lot 3 a little bit more developable than it is today, because it was a very narrow building area because of that easement that's along the east side or west side of that particular lot. As you can see, this has frontage on South Redwood Street, and that's the what Peter was speaking to earlier under public comments, that this South Redwood Street is county jurisdiction. And so they have the say about how and what kind of improvements are necessary. And generally speaking, when you're doing a partition, any street that isn't built to city standard, or in this case, county standards, is subject to 1/2 of that adjacent street being improved to, in this case, county standards. And so he'll be dealing with the county with either paying a fee in lieu or making the necessary improvements before he can file this plat of record, if approved for this partition. Then the city owns the 9th Avenue, and because it's a local street classification, a lower classification of street than the collector classification that Redwood has, there was a relocation of this home's driveway that used to go over to Redwood to come now down from a new driveway that will be on the lower classification of street. And that was a requirement in our code, and it was also an early requirement of the county when there was discussion of doing actually an entire subdivision in this area. So you can see the 3 new driveways shown in proximate locations on the south of these new parcels. And that's important so that we can judge whether we believe that the right spacing will happen once development occurs. And it is capable of having the proper spacing from the intersection and between the driveways. A couple conditions that are unique to this request. The very first condition is technically taken care of. Last Wednesday night, the City Council passed the second reading of the rezoning that was before the Planning Commission that changed the zoning to R1.5 so that he could create these lots a bit smaller than what the original zoning was. And that ordinance has been approved now, and this condition just says that the comprehensive plan and the rezoning map need to be officially changed, and the ordinance is passed that direct us to do that, and they have been now. They technically don't go into effect until 30 days after the action on September 20th. We have another indication of street trees, and those would be just along the 9th Avenue frontage that the city has jurisdiction on. And they are very narrow, and with the driveways there, it'll have to be judicious in how you place potential new street trees in this area. And he has the option of developing a street tree plan or just paying the fee based upon one tree for every 30 foot of linear frontage. And so we're going to encourage him to try to do a street tree plan prior to filing the plat of record as well. And we put another condition for any utility easements that might be needed along the Redwood Street frontage or the 9th Avenue, just like I had talked before. We're again indicating that no driveway is allowed onto South Redwood Street because of its classification and having frontage on a lower classification street. And I also mentioned that the two lots that are being created that are vacant and will be sites of future homes are potentially subject to our infill standards in the code, and we'll check that to be absolutely certain at the time of the building permit to see whether there are indeed two existing homes that are within 25 foot of those property boundaries, which would then subject it to the infill standards. We do have some conditions of approval by our city engineers, so we indicated that they needed to be followed, and that all the recommendations that we received from Clackamas County and were sent to the applicant as well, that they'll have to be followed as well in completing this partition. So we did recommend approval of this partition with the conditions of approval indicated in the staff report.
Thank you. Any questions? Mr. Hostetler, if you wouldn't mind repeating your name and address for the record, that would be great.
Peter Hostetler, 10060 South New Era Road, Canby, Oregon. Again, what was discussed at the city council meeting is that there's a shortage of R1.5 zoning in town, and so this partition would create more lots zoned 1.5. So I think that's why, you know, it's a big plus for the city based on that fact. And other than that, if there's any questions, feel free to answer them.
Any problem with the conditions that were laid out by the city?
No, I'd just like to point out the county road, we had no problems conforming to county code, but what we had originally submitted was a subdivision, and the north lot was going to be divided into its own lot as well. And the county, what they specified is that the current house that 853, which is the northern lot, has a driveway onto South Redwood Street that we wanted to retain. And what the county was saying is if you're going to make this a subdivision, we will no longer allow any access on South Redwood Street, and all access for all lots, both 861 and 853, will need to come off of 9th Avenue. So they kind of held our application hostage because, you know, they want the city to take over this Redwood Street, and they weren't going to allow us any more access on it at all for any of the lots for any of the existing homes. So the subdivision became mute because there's no way we're going to eliminate access. We couldn't even get 5 lots on there like we originally wanted if we were going to have to take access off of 9th. So we're going to go about it the slow route, which would be doing 2 different applications and eventually, you know, partition the northern lot and have 2 lots there and achieving the same ends, but by a much more lengthy process. So it's unfortunate that it has to be extra onerous, but it is.
So if at a later date the city were to take over Redwood Street, would that alter your plans for the The northernmost,
No, it wouldn't alter my plans. I could, in fact, when this is all done and replatted, I could partition the northern lot. And simply because it's not a subdivision, but a partition, I'll get to retain that access on South Redwood Street. I mean, it's a game of semantics.
okay. Any more questions for Mr. Hostetler? Okay, thank you very much, Peter. Are there any other proponents for this project? Are there any opponents? Or is there anybody that is neutral that would like to speak on the matter? Hence, no rebuttal. So I will entertain a motion to approve a minor land partition of 861 South Redwood Street into 3 parcels and lot line adjustment to the existing lot line between 861 and 853 South Redwood Street, MLP 17-06 /LLA 1702 Hostetler, with the conditions recommended by the city.
I make a motion that we approve MLP 17-06 /LLA 17-02 Hostetler with the conditions of approval by the commission staff.
Do I have a second?
I second.
All in favor say aye. Aye. Opposed? Thank you very much. Final decisions. These are final written versions of previous oral decisions, no public testimony. Do I have a motion to approve MLP 17-05, Craig Galvin, Jeff Gordon?
Mr. Chair, I move we approve MLP 17-05, Craig Galvin and Jeff Gordon.
Second.
All in favor say aye.
Aye.
Opposed? And then I will entertain a motion for MLP 17-06 /LLA 1702 Hostetler.
Mr. Chair, I move that we approve MLP 17-06 /LLA 1702 Hostetler.
Second.
All in favor say aye.
Aye.
Opposed? Okay. Larry, why don't you go ahead and sign that? Any items of interest from the staff?
Oh, just what we've indicated on the agenda is that your next regularly scheduled meeting, we have a let's see, is it South Ivy Park subdivision proposed? And I might note that we just received a petition today with 50 to 60 people in opposition to that particular request.
That's for the next meeting scheduled for
October 9th. And then for
It's been a hot topic online.
the 7-acre subdivision, that has been re-advertised and continued to the October 23rd meeting.
any items of interest from other commissioners?
Well, I was interested to hear what Mr. Hostetler had said about South Redwood, the ability to bring that into city ownership. I think it would be beneficial if we were to take a look a little bit further at that and see what the pros and cons would be of obtaining ownership of that street for improvement purposes.
I'm glad that he mentioned that. For those of you that aren't aware of that issue, it's been a really hot topic for 15 to 20 years in Canby. And as we experience more development and the roads deteriorate, it becomes even more of an important topic. And there's this year was the first year ever that the county actually had some money to offer some modicum of payment for us to take those over. Before that, we weren't considering it at all. The city administrators prioritized one street at this time to take over, and that's South First Street. And there'll be others down the road.
Does the city maintain that street now?
We don't
Even though
maintain
it's
any
not-
of these streets that are county
So all those
jurisdiction.
holes in that road, because I live off of Redwood,
They're
are
all county responsibility.
So why didn't we take them up on their offer?
It's a matter of having the ability to maintain those streets down the way, because we're accepting, even with a modicum of a payment, it doesn't come anywhere close to the costs that we're then going to be burdened with down the road. So when people do come to us and say, when are you going to fix the street? Now it's yours. We want to be able to respond, and we're nowhere in a position to be able to redo all of those streets. But over time, we'll get there, because we do have a street maintenance fee in Canby, and it's making some good progress on the existing streets in Canby, and pretty soon we'll be able to take over and help take over some of those county streets and also improve those too. But right now, we don't have the ability. We'll take them over, and then people will be yelling at us instead of the county without being able to improve them, because it's a matter of prioritization. There just isn't the money there. That's why the county isn't doing it. They have some other reasons too. Since they're in the city, they want to prioritize working on their roads outside of the city limits. And so that's why we know they're never going to get any better if we leave the situation as it is. But there's a lot of cost involved in taking over these roads.
I don't understand how you can annex county property into the city and not get the roads at the same time.
Yeah, I don't really know, since all of this has happened way before my time here. But when you annex, there's separate actions to changing the jurisdiction of the streets. So the annexation itself doesn't do that. There's another action on both of our city council's agenda and the Clackamas County's agenda for agreeing to transfer those ownerships. And it all goes back to a intergovernmental agreement that we have with the county that covers a lot of topics, and this taking and changing jurisdictions of road is one of those topics in that intergovernmental agreement. And I can't remember whether it's 1999 when it was signed or somewhere back in the 90s, and it talks about the county providing a 2-inch equivalent of a 2-inch overlay when we do agree to take over a street, and they have been unable to do that until the possibility this year of providing that. So there might be some more progress, down the road now that they're finally proposing anyhow to start living up to that agreement and providing some monetary incentive.
What are other streets? Oh, I'm sorry, go ahead. That's right.
From my experience as a civil engineer, I've come across a lot of small towns like Canby that have county roads that go clearly through town, 1, 2, 3, 5 roads that are county maintained and owned. And the reason why smaller towns and even mid-sized towns don't try to take over county roads is Brian's right. It's the future cost of maintaining those roads is enormous, and there's no new real monies coming in to help fix those roads and maintain them. So that's the primary reason why most towns don't take over roads, is because of the costs. They might offer you some money up front that might help you for the first 5-10 years, but after that, then you're on the hook to maintain them.
So it's a bit of a dilemma, because if the county's not going to maintain it, the city's not willing to take it over, they don't get heal on their own, so to speak. They just get worse.
They do, and we hear about it more and more and more, and Currently, what we have to do is direct them to make those complaints to the county, which the average citizen just doesn't understand. They can't understand why they're in the city, so why aren't they the cities? There's actually unique to Canby pretty much the fact that some of those county roads are drained into underground injection wells that drain the stormwater runoff that falls on those. And there's also some potential issues with that as a cost factor as well.
I think it's important to note that if you ever think our roads are really bad, spend some time driving around the city of Portland.
Right? Yeah. No,
Those are
No, thank you.
really bad.
I avoid that as much as I can. Unfortunately, I work there.
We'll make you thankful for the roads that we do have.
So as we develop those areas on Redwood, for example, then developers are not required to improve the roads.
So actually, if it's a local classification street, our intergovernmental agreement says that with an annexation, they are supposed to become a city's jurisdiction. I don't think they've been religiously following that in the past, or some of them would have had segments. So the whole road wouldn't, but where the frontage is next to the subdivision would have changed jurisdiction. But you can see that's kind of problematic. Then we have one block that's the city's, the next block that isn't, and then another block that is. And so I think that's one of the reasons they didn't follow that practice in the past, that you really need the whole section to go at once and just agree to that. And we've done at least 3 of those from Southeast 13th, from the intersection with Ivy, eastward out to, what's the street where the school road comes down, out towards the new Feist addition and Timber Park that's being built out that way. It's city's
Teakwood?
jurisdiction
Teakwood.
now. Yeah, Teakwood. So to Teakwood is now city's jurisdiction, where a few years ago it was county all the way to Ivy.
Well, the Redwood development was all put in 93 and 94. Because I'm the second house in that whole development, and I moved in January 94.
You don't mean Postaway and those areas out there?
All from township
Oh, it's
past the
down
school and down south, north of 9th, where this guy's at. It's all old.
Well, the
lots.
intergovernmental agreement says we will not take over arterial streets that are on the edge of the city. So it has quite a bit of discussion in there about what to do about these streets, but we haven't been really following it, what's in that agreement, partly because there wasn't any incentive with the money available. But it's a confusing matter, but it's a very important one, and it's very important to planners because we see this every day. And so I've been very aware of our inability, because there's so many of them and they're different sections of roads of the same road that are county versus city, that we just have to have a really strong checklist to check it with every application, and we miss them occasionally. And so our only alternative is to notify the county of every single application that's made in the city. So they can look at their map and say, oh, yep, we want to comment on this one because we're in charge of the street. That way we don't have to remember ourselves. It's the only alternative we can think of, is to quit missing these and causing problems from that standpoint.
You're a troublemaker, Brian. Just a troublemaker. I've known that for years. Any further comments, questions? I'll entertain a motion to adjourn.
Mr. Chair, I'll make a motion to adjourn.
Second.
All in favor, say aye. Aye. Opposed? Thank you very much.